Good evening, friends. Since the AOR exams, Advocate on Records exams, were around the corner, we requested Dr. Charu Mathur, an advocate on record, and who's also known as a well-known resource person, to understand the nuances for the same. And today's session is Practice and Procedure before the Supreme Court of India, a practical roadmap for AOR candidates. This session will be, as usual, a combination of Hindi-English. We are quite sacrosanct that people would cherish it. Thank you, everyone. And over to you, ma'am.
Thank you, Vikasji. Thank you, Beyond CLC, for inviting me. So, as we all know that today we will be talking about practice and procedure, and our focus will be more towards the examination, upcoming examination. So, before I start with the practice and procedure, let me just tell you that practice and procedure of Supreme Court is the core paper. It is paper number 1 in the AOR examination, and you have to prepare it in a certain manner. Now, as far as this paper 1 is concerned for practice and procedure, see, you have to be aware about the brief history of the Supreme Court, how the Supreme Court came into existence, what was the structure before the Supreme Court came into being, that is, before the Constitution has come into being. So, as a lawyer, you should be aware about, I always say that one must be aware about whatever is the socio-economic context of that era when this particular thing was enacted. So before being of the Constitution, what was the situation that country was facing at that particular time? So anything that we talk about, that has to be taken into the context of their existing situation. Now coming back to your Supreme Court's practice and procedure, the key thing that we need to remember is the Government of India Act 1935. So as far as the Government of India Act 1935 is concerned, it had enacted federal court. So federal court was the thing from which we take our constitution, from which we in fact take our Supreme Court, how it came into being. So as far as your Supreme Court is concerned, so we have to go back and look into the time when federal court was constituted. So as far as the federal court is concerned, it has typically had 3 judges. So one, the Chief Justice was always an English person, and one Hindu judge and one Muslim judge were there. So at the relevant point of a time during the history, as far as the Indian judge was concerned, it was Justice Kania who was there, and then his 2 other brother judges were there. So that is how Justice Kania became the Chief Justice of India when the Constitution came into being. Sometimes you are also asked to be made aware of how where the Supreme Court was sitting before this building was constructed. So if you look at the old Parliament building, there was this Chamber of Princes, and that is where the federal court used to sit, and there in fact the Supreme Court started its very beginning in the chamber, in the Prince's Chamber in the old Parliament, as we call it now. Now, as you all know, the Constitution came into being on 26th January 1950, and on 28th January 1950, the Supreme Court, as to say, was inaugurated. Now, this was a historic moment. It was widely covered, and the inaugural proceedings, they were attended by the Chief Justice of India, who was Hiralal Kania, J. Kania, and then there was Sir Syed Fazal Ali was there. There was Justice Patanjali Shastri was there. There was Meherchand Mahajan was there, B.K. Mukherjee, and S.R. Das. And later, as the Supreme Court went on to grow, Vivian Bose also became the part of the bench. But on 28th January 1950, he attended as the inauguration proceedings as a Chief Justice, as a judge, as a Chief Justice of one of the courts. And in this matter, when the Supreme Court was inaugurated, Mr. M.C. Setalwar was there as the Attorney General for India, and it is worth noting that the then Chief Justice Kanya, he said that what we are giving is the when the fundamental rights were incorporated under the Constitution, right? And then there was Article 32, which was there in the Constitution. So he very categorically said that we are there as the custodians of the fundamental rights of the people. We are here to preserve and protect them. Now, with this, we come to the what Dr. Ambedkar has said is the heart of the entire constitutional scheme. That is your Article 32. Now, what does Article 32 say? Article 32 says that if there is any breach of the fundamental rights of any citizen is concerned, then that citizen can move to the Supreme Court. Now, the interesting thing about Article 32 is that it is included in the Part 3 of the Constitution, which deals with the fundamental rights. Now, often the question is asked that which article is considered as the heart and soul of the Constitution, and you are being asked to distinguish the powers between the Supreme Court and High Court under 32 and 226. So, of course, the powers under 226 are wider because they provide you justiciability of fundamental rights as well as other legal rights, while 32 talks only about the fundamental rights. Now, why 32 is soul of the Constitution? The reason for this is that if you have fundamental rights, right, but if there is not a assured remedy for that, then they become meaningless. So the framers of the Constitution, they have decided to put fundamental rights as a justifiable right itself. The guarantee to enforce that is also a part of the fundamental right. So it is part of Part 3 of the Constitution that ensures that it remains the 100% justifiable. If there is any breach of the fundamental rights, then citizens have right to move to the court. Now, this over the period of time, Article 32 has evolved, right? So when you look into 80s, when you look at Justice P.N. Bhagwati's court, he went into what he's called as a social engineering, lawyers as the social engineers, and he went on to have that social action litigation, which we called as the public interest litigation. So at that point of a time, public interest litigation, it flourished, and anybody who feels that there is any wrong done, or if there is anything that has to be done in the interest of the society, so he gave birth to public interest litigation, and it was very well received by the courts. And there are many things that have been done under Article 32 of the Constitution. Now, while doing so the Supreme Court has actually innovated, and it went beyond the traditional 5 writs, and it started something known as the continuous mandamus. So even if you look today, whether you are fighting pollution, whether you are fighting landfill cases, whether you are fighting for the solid waste management, the remedy still goes in MC Mehta's case, which is a 1985 matter. So there is a continuous mandamus which is coming. So it is not, generally we file a writ petition for a mandamus in that particular cause. So generally you see that lawyers in Supreme Courts and High Courts, they will be filing 1-point petition and they are seeking a mandamus on that or whatever remedy they want. But under the PIL, they have started something known as continuous mandamus. So even today when we are fighting air pollution, whether we are fighting felling of trees, so that has actually made Supreme Court of India as one of the most powerful institution in the entire world. No other Supreme Court you will find as powerful as the Supreme Court of India. And Supreme Court judge, he wields power over on the every aspect of your life. Whether people can go in for abortion, it is right or wrong. Supreme Court can decide. For everything, whether there is a harassment at workplace, even when the legislation was not formed, Supreme Court in Vishaka laid down the guidelines for that, right? So Supreme Court has, over the period of time, because of its constant innovation, has become the most formidable body before in the entire world. Now, coming on to the jurisdiction of the Supreme Court, of course, you have the original jurisdiction of Supreme Court under Article 32. And for that, when you file a petition, when you draft a petition, you, under the Supreme Court rules 2013, you have to specifically plead that there is, what is the fundamental right which is being breached. Then if you are filing a 32 petition as a public interest litigation, there are certain guidelines for the public interest litigation that are to be followed. Like the person who has to filing, he has to give an undertaking that he is not interested. It is not a shady kind of litigation that he is doing. He has to disclose his source of income. He has to tell him what is he doing in the life. So you have to establish your credential before the courts. Though in the public interest litigation, as we all know, the rules of locus standi, they have been diluted and they are not strictly adhered to. Under 32, a person can file when his or her individual fundamental right is also breached. Now, this leads to a question that who all can move to the Supreme Court under Article 32? Is it only the natural person like us who can move to the Supreme Court, or even association of persons or corporations can they move? So over the period of time, the court has realized that even the juristic persons are recognized as persons, and if their rights is infringed, they can also invoke Article 32. Likewise, there is a question that when can you invoke Article 32? Whether it should be invoked when there is actual breach of the fundamental right, or can it be invoked when there is a perception that it is going to be breached. So Supreme Court has said that even when there is a perception that it is about to be breached, suppose it is invoked in the Tisco's case where the issue was that the tax was to be recovered. It was not actually recovered, but the provisions were there and there were chances that it will be recovered. So in that case, you have to file, the court says that 32 can be invoked. So if you look at the case of Ujjambai, which actually tells you where and when can the provisions under 32 can be invoked. Now thereafter, I will move to the other jurisdiction of the Supreme Court, which is the appellate jurisdiction of the Supreme Court. So you have Article 131, you have Article 132, 133 and 134 of the Constitution. First, I will talk about Article 131, which is a special provision which says that if there is any dispute, this is again an original jurisdiction, sorry, that I am talking about. If there is any dispute between the state and union, then they can invoke Article 131 of the Constitution. But here, only two things that you need to remember. First, that it is in relation to the parties. So parties can be only state and union, right? And it cannot be any subsidiary of the state. It cannot be any government-owned corporation. So you cannot file a case for damages against Indian Railways, right? Under Article 131. For that, you have to file a regular civil suit only. And the subject matter that is under Article 131 is one which relates to the interpretation of the constitutional provisions that are there. So what is the relation between state and union? That will come under Article 131. Now thereafter, I'll move to the appellate part, which is your Article 132, which deals with the those matters where there is a question of constitutional questions which the High Court think that should be answered by the Supreme Court. So Technically, even a single judge can refer the matter, but the practice has been, and it has been depreciated, that single judge directly referring the matter, certifying it that it should be answered by the Supreme Court. It should go to the division bench, and division bench should decide whether this is a question which requires interpretation by the Supreme Court. Likewise, under Article 133, you do have the provision when the civil matters are concerned, you can file appeal to the Supreme Court if the High Court certifies that this is an issue which requires a consideration by the Supreme Court. And then you have Article 134 of the Constitution, which specifically provides that if there is a death penalty is being imposed by the High Court, then you can file. And the situation it gives, first situation it gives, suppose the trial court has acquitted and High Court has convicted that person and giving him death penalty, then you can approach the Supreme Court. Likewise, if the High Court has withdrawn the case from the trial court and given the death penalty to a person, then you can invoke. Now, again, there is a minor innovation which was done, that they realized that there are not so much death penalties, but there are life imprisonment was there. So, as you know, Supreme Court rules, they are formulated under Article 145 of the Constitution. Now, the Parliament has enacted enlargement of a criminal appellate jurisdiction of the Supreme Court, and it says it is only a 2-section enactment, which says that if acquittal has been converted into life imprisonment by the High Court, then as a right of appeal will write to the Supreme Court. Now, one more thing that you need to remember is that period of appeal under Article 132, 133, 134 is 60 days. This is in contrast with SLP, where the period of limitation is 90 days from the impugned judgment. Then we come to Article 136 of the Constitution, which is extraordinary appellate jurisdiction of the Supreme Court. And this is the bread and butter article of us practicing before the Supreme Court. So as far as Article 136 is concerned, it is extraordinary appellate jurisdiction, and from any order of any court. So even if there is an order of a session judge or of any tribunal, if you are aggrieved by this, technically you can move to the Supreme Court under Article 136 of the Constitution. However, in practice, the court says, the Supreme Court has laid down that you can do so only in the case of when you have exhausted the remedy and then you are coming to the Supreme Court. Now, Article 136 is the discretion of the Supreme Court judge who is hearing it, whether he or she thinks fit that this is a case where they should interfere with the decision of the High Court or whichever forum it is being appealed from, right? So it is basically a discretion, and that is why you will find that there is a wide discretion that is being awarded. So in Supreme Court, if you see 90% of the matters, it is said that SLPs are dismissed because it is the discretionary jurisdiction. And they said that this matter should have been rested at the High Court stage and you need not progress further. Now, at this point of a time, I would like to talk to you about a very important doctrine called doctrine of merger. Now, as far as the doctrine of merger is concerned, which says that at any given point, right, you can have only one standing order. So, generally, if you look at the SLPs, you will find that they are dismissed in limine. That is to say, they are dismissed in only one word. We don't find any reason to interfere in this matter, and hence we are dismissing it. Or simply you will say dismiss. Happiest is when you say notice issued, right? As a lawyer, we are very happy to hear that. But the question is, what is doctrine of merger? So, suppose there is a matter which comes to Supreme Court under 136 or in any other forum, but right now we are talking about 136. So if the matter is yet simpliciter dismissed, so court said it is dismissed, we don't find it fit to interfere. then what is the final order in that case? So the final order in that case will be the decision of the High Court. The impugned order will remain the order which will be there to settle the whatever the list between the parties. But suppose Supreme Court admits the matter and it gives the decision. Now it can give the decision which can uphold the decision of the High Court, which can reverse it, or which it can modify. So in that case, the Supreme Court, the decision of the Supreme Court will be final, and the impugned decision will get merged in that decision of the Supreme Court. So that is your doctrine of merger, right? So at one point of a time, only one decision will be final and binding in the between the parties. Now, there are many issues that come under Article 136 that what will happen, can the court mold the relief, right? So the Supreme Court, even under Article 136, can mold the relief even if it is not been asked. So if you look typically at the prayers in the SLP, the prayer is generally one that grants special leave to appeal against such and such order. So that is the only prayer that you make. Now, when you file SLP, suppose its number you get is SLP Civil 123 of 2025. Now, there is a concept called leave granted. Whenever you read any judgment from the Supreme Court, you will find the first para as leave granted. What is the meaning of this word? Leave granted. So, this phrase leave granted means that the petition that you have moved, your SLP that you have moved, it is actually special leave to appeal which you are finding. So court says that it is going to interfere in this matter, and it says that it has granted the leave. So this number SLP 123 of 2025 will change into Civil Appeal 3 of 2025. Suppose this is the numbers I am giving. So now the number has changed. Now the number of the petition, which was SLP 123 of 2025, will become Civil Appeal 3 of 2025, and the decision that will come will be in this special leave, will be in this Civil Appeal. So the first line that you find in the Supreme Court order is leave granted, and then they proceed with the decision. So this is very important aspect. Likewise, when we move from Article 136, next thing that I want to talk to you about is the transfer petitions in the Supreme Court. So in Supreme Court, you get a lot of transfer petitions under Section 25 of CPC as well as under Section 406 of CRPC. So when you want a matter to be transferred from one state to another, then you require to invoke this provision of transfer petition. Likewise, even under the constitutional scheme under Article 139A 1 and 2 of the Constitution, you have the right for transfer. Cases are being filed. It is transfer cases where they feel that if the similar matter is pending before various high courts, then you ask them to direct the Supreme Court to rather the matter be pending. If there is an issue involved, let either the Supreme Court or it can nominate one of the high courts to decide the matter rather than courts going everywhere. So that is another provision that you must be aware of. Now, another important jurisdiction that courts invoke is Article 143 of the Constitution, which is the advisory jurisdiction of the Supreme Court. And this is one jurisdiction which is lots of news in these days because of the presidential reference. So you can recollect that two-judge bench of Justice Pardiwala and Justice Mahadevan, they had said about what are the governor's power, plus they have act that governor cannot indefinitely keeps the bill pending, and the president should decide this within 3 months. Now, this has led to a constitutional situation because Article 200 or other provisions of the Constitution, they do not provide for a time frame within which the president must give his or her assent or denial to any bill which has been put for his or her approval. So the question which has been 14 question in fact has been sent by the President of India regarding what is the timeline under which can there be a timeline for the president to decide on these matters. Right, constitution is silent on that. So the Supreme Court is asking for an advisory for the same, that what is the procedure which can be undertaken. So advisory jurisdiction, one thing that you need to remember is it is not an obligation on Supreme Court to answer every query which has been put by the President of India. They can refuse to answer the query, and they have done it quite a few times. So like initially when this Ram Mandir Babri Masjid dispute was come to the Supreme Court, as in the guise of the presidential reference. So they said that you cannot refer to us on the political cases to us. If there is a political matter, you go and fight out on the ground with the people. Don't use Supreme Court as a plan to fulfill your political ambition. Thereafter, the next thing where the Supreme Court has said that we will not be answering these references. So a reference they can ask. The question which is asked in the examination is what is the binding value or the precedential value of these of the opinions given by the Supreme Court under the advisory jurisdiction. So the proprietary demand, the Supreme Court has answered that since it is an opinion coming from the Supreme Court of India, it has to be given due weightage by the courts, even if it is only an advisory jurisdiction and not actually deciding upon lists by any party. So the court said that it is important that a due process, there's a due value must be given to the presidential reference. Thereafter, we have Article 142 of the Constitution, and it is a very, very important provision because it grants the court power to do complete justice between the parties. Now, generally speaking, Article 142 was used only for those cases where there was a dispute between the existing parties which are before the court, and they want to decide on that. So how to end that list qua those two parties. But of late, Supreme Court started invoking Article 142, like in the Union of India versus Ashish Mishra in a tax matter. The court says that we can invoke 142 even to quash the pending litigation before the various high courts as well as before this court, because we are settling this issue and so we don't want you to continue with this kind of litigation. So this is another area where many people find it really disturbing that Article 142 is being invoked. Likewise, when you look at Article 141 of the Constitution, which demands that every person, right, which demands that every person, every authority must come in the aid to implement the decisions of the Supreme Court. So this is their duty, which all the organizations, they must follow. Thereafter, I will take you to the review and the curative jurisdiction of the Supreme Court. So review jurisdiction says if there is a manifested error apparent on the face of record, you can move a review petition. Review is to be filed within 30 days, and you have to show what gross illegality is being done, right? But remember, review cannot be an appeal in disguise, right? You don't have the provision of intra-court appeal in the Supreme Court. Likewise, in Rupa Ashok Hura, Supreme Court innovated curative jurisdiction, and they said that if even the review petition is dismissed, Then also you have a remedy by way of curative petition, and it has laid down stringent guidelines that a designated senior must show that this is a case which actually requires consideration by the Supreme Court and it has lapsed. In practice, if you see 99% of reviews are dismissed, and in curative, less than 1.1 or percent of curatives are allowed. But if you look at the curatives, they have been allowed in very, very important cases. Likewise, if you look at whether the provision relating to under sections 377 of IPC, right, which deals with the criminality of the homosexuality. So, as you know, in the Nas Foundation, Delhi High Court upheld it. In Swaraj Kaushal, the Supreme Court has said it no. So, review petitions were also dismissed. So, one person by the name Navtej Johar said that I am the person who is directly involved. They were all the foundation. I am a person whose fundamental right is breached. So kindly hear me out. So despite being everything, court said that okay, because it is an individual's fundamental right which is being heard, so we are going to hear it. And so we have the historic decision of Navtej Singh Johar. Likewise, in the recent 7-judge bench of in the re-arbitration intraplay that they have given the name, again they have opened a case where they said that whether this arbitration clause, whether it will be binding nature or not. So this is a case which they reopened, which was long dead case of 9 or 10 years, which was decided. So this is actually a very disturbing trend where today a chief justice might be doing it in a good faith. But tomorrow, if somebody does not want to use it in a good faith, or they don't want to follow certain international precedents as they wanted to follow in this arbitration case, then it can be a problematic issue. So in practice and procedure, the one thing that we must remember, and in fact, which should be carried out, that there must be a consistency of the practice, right? Whatever procedure you are following, it should be followed to the hilt under why you are invoking curative petition. Under curative petition, why is it going to 7 judges bench? Why they are invoking this provision? Under what reason? You as a judge might have an idea that this is wrong, but you have to wait for the right case to come to you. You cannot just say that, oh, because I think that this is wrongly decided by 5-judge bench, so I should make it correct. Right? I mean, this is actually, in my opinion, it can be termed as an overreaching by the judicial, by the bench itself. You have to, even the judges, when they feel that something is wrong, something is to be corrected, they have to wait for the correct matter to come before it. And there is even a procedure how a matter goes. See, generally Supreme Courts, they sit in the division bench only, right? In the benches of 2 and 3 judges, that is how they sit. When there is a constitutional issue is there, or the matter is referred to a larger bench, it goes to the 5 bench. From 5 to 7, 7 to 9, 9 to 11, 11 to 13 is only Keshwanam Bharti. But it cannot be that you feel because it is being done wrong, so you said that no, 7-judge bench will be here. You pass an order that this is a matter which requires to do. So that is a battle that we will fight it another day if we get a chance to do those particular cases. Now, coming back onto the jurisdiction of the Supreme Court. Supreme Court, there are various appeals which come to the Supreme Court from various tribunals, whether it is your NGT, whether it is your NCDRC, or whether it is your NCLT, from where these civil appeals, they come directly to the Supreme Court, and even from the bodies like Bar Council of India against a disciplinary proceeding. Now, there is a strict timeline which is required to be followed. This is a 45 days time limit is there within which the appeals have to be filed. And for that, you need to check the corresponding act also, because it is very important. Because it is very important to know that what is the time limit prescribed. So there are apps which says that period of appeal is 45 days plus 15 days at the max at the discretion. So you have to check each app what is the prescribed period of limitation which is provided under that act. Now, as far as Supreme Court is concerned, there is a very, very high value commercial disputes which have started coming to Supreme Court. Whether you look at NCLT, the insolvency matters which are coming, or you look at the Electricity Act, under which various matters relating to tariff of the electricity is concerned, they are coming. So that is how even the procedure, the practice, and even the examination papers are changing. Where the focus was earlier on the constitutional law, now it is drifting towards the commercial law also. Now, apart from these jurisdiction and the practice and procedure, you must be thorough with the Supreme Court rules 2013, and you should keep an eye on the Supreme Court website where they come out with practice directions. We don't call them practice directions as such, but these are various notices and circulars. So today, after the e-filing has come, so earlier when we wanted to request to the court that these are the files, these are the books that you kindly keep it ready for the court. Today we just send them an email with a list of the book that these are the books which we are requiring for the judges to have. So you must be aware of these directions which come. So if you want to move for an adjournment, you need to know that this is an email ID on which you have to do. Then when you want to go for your mentioning, there is a procedure which is there which you have to follow. There is a mentioning form. How do you make a mentioning before a Supreme Court, right? So earlier in Supreme Court, before it was not before the last CJ, that's depreciated the practices of senior advocate coming, a designated senior advocates coming and mentioning the matter before the court, right? Because I don't know if you are aware that even the senior advocates who were mentioning the matter, just to mention a matter, they used to charge a bond, right? So 5 lakhs for mentioning, 7 lakhs for mentioning was not unheard of. And mentioning only just get the matter listed. So it is being streamlined. There is a mentioning registrar. There is a particular form in which you have to give the reason why you want to get this matter, why it should be heard out of turn. Likewise, there are various other things that you must be aware of is regarding the e-filing procedure in the Supreme Court. How do you file before the Supreme Court in the e-format? How the file moves. Once you file the matter, from where does it go? Does it go to the D-Link, then to section, then to assistant registrar? Then how the defects are cured? If the caveat is being filed, how do you file the caveat? If the caveat is there in the matter cannot be passed until and unless there is a caveat clearances. So earlier the matters used to get listed even before what you say, the caveat is being, even if the caveat is there. But now with more and more technological advancement, it has become easier to follow that until and unless there is caveat clearance, there will be no this thing. The matter cannot be verified. So in Supreme Court, we have this typical thing called verification. Everything is done. Thereafter, again, they will verify that all the checklist is being fulfilled. So these are some of the procedural things which you must be aware about in the Supreme Court practice and procedure. Now, thereafter, there are small things that a person must be aware of, like what will happen. Suppose you want to mention an urgent case, like how do these people get midnight hearings, right? what is the procedure? How do you do it? So the answer is that you go to the registrar. See, every time there is a vacation registrar is there. There is always a registrar you will find on duty. Their telephone number is given. You say that it is such and such cause and we want an urgent hearing. So it is not only in the cases of death penalties where the execution is to be held, but there are cases when the chief ministers have taken oath at 6 a.m. in the morning because the Supreme Court was moved at midnight and they heard the matter till 3 a.m., 4 a.m., and then they gave the decision. So you have to make a case for grave urgency in the matter and get the matter listed. So as an AOR, your primary duty is to draft the matters, ensure that it is as per the procedure of the court, get it listed. And most of us as AORs, we argue our matter. But there is a peculiar practice that has been developed in the Supreme Court over the period of years that you take a designated senior because this is a last port of resort for any litigant, right? After that, he does not have any recourse available. And that is why people don't like to take any chance. So that is how they go and they would like to file the matter before the Supreme Court. So this is what broadly will come under your practice and procedure before the Supreme Court. So for this, I can even suggest some books to you. You have to be thorough with the Bare Act of the Supreme Court, which is Supreme Court Rules 2013. You must be well aware with the provisions of the Constitution, particularly which deals with the jurisdictional aspect of the Supreme Court. And if you look at the book, then it is by Attorney General R. Venkataramani's book on practice and procedure of Supreme Court that covers the latest law, the latest amendment. It is updated book. So you can consider that book by R. Venkataramani sir, the Attorney General for India. Yeah, a very well written book with which you can follow. There are other books also like B.R. Agarwala's book is also there. But it needs to be updated. And I've heard that a new version has come, but I have not seen it yet. So, because some questions do come, on the comparative of the various countries and the Supreme Court of the various countries and Indian Supreme Court. So, Venkataramani sir's book, it covers in greater detail as far as those aspects is concerned. Then often a question is asked upon the judicial review power of the Supreme Court of India. Does Indian Supreme Court has a power to judicial review? Most countries, most Supreme Court, they don't have this power of judicial review. And this is the power of judicial review which makes our courts one of the most powerful court in the world. So this is essentially what I have. Now I'll open the floor to you. If you have any queries to ask, please ask. Because anybody with any queries? Because you are on mute. Any queries? Because if you can't unmute, you can type it out also.